Does a stranger visits your place quite frequently? Has your neighbor started construction in your backyard or in your property? Is someone claiming your property to be his and you are afraid that your property will become his? These are the circumstances in which a man may come and start feeling helpless. Then you need to know certain points regarding the circumstances which may help you while dealing with the situation. First question is it an illegal or legal act? So let's see. Yes, it is an illegal act. So claiming a property to be yours or doing any kind of constructions on the property which is someone else's property is an offense in India. There are provisions in the Indian Penal Code and Civil Procedure Code which deal with the crimes related to property. The provisions of law which refrains a person from entering someone else's property without his or her consent is known as trespass. My name is Nirmal Kumar Jain and you are watching Let's Learn Law episode 6 on Law Gardener. Do watch the whole video to know about trespass, punishment and remedies. If someone tries to interrupt you while you are within the territory of your property, may be arrested for trespassing. Trespass in simple words is disturbing a person or even entering a person's property by an unauthorized person without or against his or her consent. Trespass are basically of three types: trespass of person, trespass of chattel, trespass of land or property. We will cover trespass of person and land or property in this whole video. Trespass of person is an act in which a person without any authority or the consent of the aggrieved person disturbs or intervenes the person from doing what he was doing before he was interrupted. Trespass of person has been explained in the law of torts. And also, trespass of property or land is an act in which a person without any authority or the consent of the aggrieved person disturbs or intervenes with the property or land of a person. Trespass of land has been explained in the law of torts as well as in the Indian Penal Code and it is a punishable offence. In IPC we come across with the criminal trespass and house trespass. As per the section 441 of Indian Penal Code 1860, if any unauthorized person enters upon the property of another person without his consent, then he shall be punished for criminal trespass. The punishment of criminal trespass has been defined in section 447 of the Indian Penal Code because you should give punishment, right? If a stranger has started construction on your property, then he shall be liable for punishment under criminal trespass. The punishment for criminal trespass is imprisonment which may extend to 3 months or fine which may extend to 500 rupees or both. You may think just 500? Yeah, because law was made in 1860 and you can think that 500 was a big deal in 1860. Yeah, there is a need of amendment. Now we got to know about criminal trespass. Let's see what is house trespass. Criminal trespass upon the backyard or any other part of the property which is in someone else's possession is called house trespass. So what is the difference between criminal trespass and house trespass? Criminal trespass is an intervention upon any property which is not in your possession but you are the owner. Whereas house trespass is a criminal trespass of someone's house or any portion of his house. In this you are the owner of the property or you have the right over the property and you are also possession in it. Means you are residing there or you are using the property. So basically house trespass is equal to criminal trespass plus your possession. See, every house trespass is criminal trespass but every criminal trespass is not house trespass. House trespass has been defined in section 442 of the Indian Penal Code 1860 and the punishment for house trespass has been defined in section 448 of the Indian Penal Code. The punishment for house trespass is imprisonment for a term which may extend to 1 year, whereas in criminal trespass it is just 3 months, or a fine which may extend to 1000 rupees or also both. So now what are the remedies available if some person has done these offences and infringed your right? The first move you should make if anyone starts construction over your property is try to stop him from doing it. The law gives each person a power and a right to protect your property by using appropriate measure. Section 103 and 104 of the Indian Penal Code allows a person to cause grievous hurt or even kill a person in order to protect your property.
So
But
wait.
But these powers shall only be used when it becomes necessary to use it. If a person causes grievous hurt or kill a person while protecting his property and he has used it in a situation under which he was justified to do it, he have to prove that the action he took was the only thing left and there was no other option to stop the offender. He shall not be punished for killing or for causing grievous hurt to that person, as he has not committed any offense, because what he did will be covered under private defense. The remedy which are available to you if a stranger starts infringing your right and start construction on your property which is in your possession, is to get an injunction order for stopping the construction, and you can also claim for the damages which you have suffered due to the construction. You will be thinking that what is an injunction? How does I know? Wait, we will tell you what is an injunction. So generally, injunction is the order which is passed by the court to either stop or restrain the defendant from either starting or stopping to do something. In other words, an injunction is the order of a court which demands a person to either perform an act or refrain from doing an act. Injunctions are broadly divided into two types. They are temporary and permanent injunction. So what is permanent and temporary injunction? A permanent injunction is passed as a final order restricting the defendant from doing any act. And what is temporary injunction? It is an injunction which is passed by the court to make sure no further act is done related to that property or work temporarily, which is generally given when the suit or a case is still pending in the court and it is going on. Let's take an example. Suppose you have your own property and your neighbor starts construction on your property. Then you can approach the court and file an application under Order 39 Rule 1 of the Code of Civil Procedure to get an order of temporary injunction. The court, after examining the application, will ask the defendant to file the reply on the case. The court, after examining the reply, and may either reject the application or accept it. If the court has accepted the application, then it shall make an order of temporary injunction, ordering the respondent to stop the construction work on that particular property. Suppose the defendant party doesn't reply to the court order, then what will be happen? Your right will be infringed. They will be constructing on your property. Then there is one more type of injunction that is called ex parte injunction. So it is a general rule that no order shall be passed without hearing both the parties, or in other words, it is compulsory that both the parties are given appropriate opportunity of being heard before any order is passed. But there are certain exceptional cases in which a leave is given to this rule. Means court will say bye bye to this rule and will not follow. This exception is known as ex parte injunction order. An ex parte injunction order is an order of injunction which is passed by the court without hearing both the parties. In case the defendants are not replying, or the applicant feels that by the time the reply shall come, he will bear a huge loss, and if the court is also satisfied with his contention, then the court may pass an ex parte injunction order under Order 39 Rule 3 of the CPC. It happens very rarely, and the burden of proof is upon the application to prove that his case comes under the definition of exception provided under the law. Okay, now suppose if a neighbor or stranger have destroyed your property during the construction, then you can claim damages. So basically, damages are means through which a person is supposed to get approximately what he has lost. There are certain offences for which no damages or compensation can be given what is lost, but on the other hand, there are certain injuries for which an amount of money can compensate the loss. One such offence is trespass. If someone trespass upon the property owned by you, then you may approach the court and ask for the damages which you have suffered. If a stranger has constructed or demolished any part of your property, then he is liable to compensate you in the form of damages. It doesn't mean that you can claim damages of 1 crore, 2 crore for the loss of 10 lakh, 20 lakh. So the court will decide. The amount of damages depends upon the loss which you have suffered. Damages are given for both physical as well as mental loss suffered. The amount of physical loss is usually calculated by calculating the present value of the land upon which you have suffered the loss. You have understood the law, and it is generally advised that whenever your right is infringed, you should start consulting the lawyer, and he will take all the necessary steps to protect your rights. If you felt that this video was knowledgeable, then do like our video and subscribe the channel, and also share the knowledge by sharing this video to your friends, family, colleagues, and other people. Stay safe.